Hi, everyone, and welcome to episode 25 of Immigration Talk. I'm immigration lawyer John Khosravi here with my wonderful associate, Anya Sergeyeva, talking about I-824s, follow to join, employment-based focused. These are people who get their green card while in the United States. A lot of times people from India who have huge backlogs, they're here on H-1B. They get the green card, but their spouse and child are overseas. What do you do to get them here? We're going to go into detail on that, how to fix this process called follow to join. It's really important. It's June 9th, 2022 today. I thought we talked about this because we get a lot of people reaching out asking about the situation. There's a lot, especially with the visa bulletin moving faster for India. There's a lot more people who are in the United States adjusting status with their families overseas because, as again, those people know overseas right now, the embassies are not moving cases forward. They're kind of stalled. So we have more people here faster getting adjustment status. Anya, thank you for joining us today. How are you?
I'm fine, John. Thank you so much. H-1B season is coming to an end, and I'm very happy about that.
Let's hope. Some of these things never end. It's always more. But we did our filings, and now we're going to see what happens. RFEs, approvals, and clients want to travel. It's just a big headache. But before we actually get into it, I want to remind everybody, if you haven't already, like and subscribe wherever you're watching this, on YouTube, on Facebook, on Instagram. There's a lot of different places we post this, and definitely check it out even on LinkedIn for more content just like this. And if you're interested in scheduling a consultation, best thing to do is to email us. My email is info@jqqlaw.com. And Anya's email, who does most of our I-824 cases, is Anna, ANNA, @jqqlaw.com. Again, that's Anna at jqqlaw.com. She's our resident I-824 filer, so she's the person that probably be handling the case. Definitely reach out to her. So listen, we got a family. Again, I'm using the Indian example because most of our cases are like this, but the guy's here working for a tech company, usually is a guy. Again, I'm going to generalize it, but he gets his green card approved all of a sudden, unexpected, because visa bulletin moved up, but his wife and kids are in India. How could he get them here? What is the process to get them started?
Well, there are at least two options. First one, as you, John, mentioned earlier, it's filing for I-824 form, and also once the green card is approved, you can proceed further with the regular F2A category filing, I-130 spousal petition. So there are two main options.
So one is you got the green card. Sorry, jump in, but you got your green card approved, and you do the formal announcement where you say, "Hey, now that I'm approved, go and send the case to the embassy form I-824, so that the embassy knows to start the case." Alternatively, if your green card is approved, because the I-824 sometimes takes forever and gets lost, you just file a new I-130 case. I-130 is a family petition saying that I'm a green card holder. I want my spouse and kid to be able to enter the United States. And what we do, frankly, for our case, we have both of them going at the same time because the timelines are so variable, and you just want to play both and see which one works first.
Right. And sometimes you may also try to reach out to the embassy first and to ask them if they can open a follow to join case directly with them, with the embassy, without filing I-824. Sometimes it works. Most of the times it won't work, and you will still have to file I-824. But just give it a shot. Maybe you'll get some luck with that.
Sure. And you mentioned a word, follow to join, which is a technical word that's never been properly defined in the statute, but we kind of just make up the terminology. Could you talk about what accompany and follow to join is, and what the embassies, how they differentiate those?
Well, yeah, these are two slightly different things, right? So follow on to join, it means when a child under 21 or a spouse will come to the United States. I think there is no like time frame within which they can come. And when compared to accompanying spouse and child, they have to come within, I think, 6 months, right? Mm-hmm. After the main applicant. And how they count the 6 months, is it like they have to physically come, their visa have to be issued, they have to apply for this visa? It gets too complicated with that part. So it's different even how you count this time, where the 6 months starts and where do they end.
Yeah, but practically speaking, though, for most of these employment-based cases, whether they can't as a company or follow join doesn't make a difference. Like the embassies kind of say, if a person is going to come 6 months afterwards, whatever that start date is, then that's going to be considered follow to join. For most cases, it doesn't make a difference. So we just use a catch-all term, follow to join, which is what you're going to do. There is some nuanced issues for certain categories, but we're dealing, for example, right now for a case called people who get their green card based on being an employee of the U.S. government abroad. And the way the embassy handles it, they say, yeah, follow the joint, it's all good. The USCIS policy manual in one part says, no, you can't do follow the joint, you can only do a company. But another part of it says you could do follow the joint. There's super inconsistency with it, where we've been going back and forth on with them. It's just the laws aren't clear with regard to follow the joint. The terminology has always been used wildly. But for most of these cases where someone had H-1B and they got EB-2 and EB-3, they could just do follow the joint for the family members. But one important thing you mentioned is for spouses and children under 21. That becomes a problem. If your child is 20 and a half and they're going to age out, there's a rule called this Child Status Protection Act that locks their age under 21 if certain things are happening. And part of that to lock in their age is for these kind of cases, the filing of the form I-824 locks in their age to where it is under 21. So it's really important to get that in as soon as possible if the visa bulletin, the timing, there's a lot more to it. We're not going to the Child Status Protection Act right now, but that is the way to lock it in. And then it becomes important is when do you file the I-824? There's a lot of misunderstanding and bad guidance on even government websites on this. So could you talk about when you could file an I-824 form?
Yes, so generally, form I-824, like follow to join, right? For spouses and children, it can be filed either together, for example, with the I-485 application, if for someone who's adjusting status here in the United States, okay, or it can be filed separately after the green card of the main petitioner was approved. Okay, USCIS policy says that you cannot file it while it's pending. For example, while your green card is pending, it has to be either with the initial filing or after the approval. So
yeah. And this is really important because I had recently a person contact me and their child was aging out and they needed to file Form I-824 to lock in the age. And their attorneys at a big firm said, you can't file the I-824 with the adjustment of status. And if that person waited for the green card to be approved, the child's going to age out, then they have to do an F2B category case, going to take 7 or 8 years, and maybe longer because they're from India. And so I found the part in the USCIS policy manual in their footnote that says, yes, you can file Form I-824 with Form I-485. So if you're a lawyer, this isn't the first time. I've talked with several lawyers, and I had clients of several other lawyers, and they're lawyers who have practiced 20, 30 years, experts in the field, who didn't know you could file Form I-824 with the I-485, and they were really hurting those family members. I had a Filipino nurse whose family was about to get really messed up on this because they were about to not file it with it. So it's really important to know it's in the USCIS policy manual. You can find it in the footnote in that section that goes into it. But I thought these are really important stuff to talk about because Anya and I have been talking about I-824 a lot, and the more we talk about it, the more emails we're getting from people who find these videos, and we see this is a widespread issue. Hundreds, not thousands of people, probably thousands, for sure thousands, are dealing with it. And the way they design Form I-824 is so confusing and badly designed and written that it confuses the heck out of people, and they end up, late filing it or filing it wrong or not knowing what to do. There's even other issues with I-824 where even if it's approved, you got to kind of follow up with USCIS once it's approved and say, hey, remember me, please transfer the case. We got to approve, please. You may need to contact the National Visa Center and ask them, hey, ask it from USCIS. They're not sending it. Please do the work of it. This is something typical we see as well. It's a headache from front to end, but we want to share that as well as that backup option to Plan B-ish. Obviously, you could contact the MC, ask them if they would just take it. Maybe it'll work, maybe not. But the I-130 is the interesting thing. More filing fees, more costs and stuff. But it's a good backup way to do it because right now with COVID the way it is, they give priority to family cases. So if you have an employment-based case where the I-824 is approved and they transfer the case, it's still considered an employment-based case, even though it's really your spouse and child. And so that's going to be lower priority than a marriage case or a family case, F2A. And so we might have it where the I-824 gets approved first before the I-130, but the I-824 gets stuck in bureaucracy waiting for its turn in line, and they put a priority for the I-130 case. That could potentially happen. So, we just do a shotgun approach where we say we do everything and just push it out there and get your family here as soon as possible, whichever way possible.
Right. Yeah. So we like to err on this side just to file everything, we can, because again, this is so unpredictable. For example, timelines for the Form I-824 at the California Service Center, like currently it's like 3.5 months. For Vermont, if I'm not mistaken, it's like almost 2 years.
Yeah.
And it's not necessarily if you live in California, your case will go to California Service Center.
Yeah.
It's not in all the cases. So you might be like thinking, okay, I'm going to file this form and it's going to be approved in like 3.5, 4 months. And it's not happening. Yeah. Again, it may take, as you John just mentioned, that it may take I-130 be approved faster than Form I-824.
Yeah.
So
unfortunately, This is it. Yeah, and we have people asking for expedites. It's like they're not going to expedite it, frankly. You gotta have some real good facts for them to want to do it. Everyone's asking for expedites, and as you said, like just because you're in California doesn't mean the California Service Center is going to get your case. It goes to a central location, then they just distribute it randomly. And so you have California cases going to Vermont, going to Nebraska. They're going all over the place, and those timelines for those offices are terrible. And another side thing is the thing they say on the website usually is not consistent either. It's like they'll just approve when they want. So you have two cases sent to the same place on the same day that look exactly the same. One gets approved in 4 months, one gets approved in 14 months. It's just there's no consistency in any of this. You got to expect it, and that's why we do the I-130 as a backup. Because I-130s for green card holders usually take longer nowadays, even a year and a half, 2 years. But I have random LPR I-130s that take like 6 months, 4 months. So it's just so inconsistent that you just got to do what you got to do.
Yeah, and one more thing, like currently F2A category, which is spouses and children of green card holders, it's current. So there is no wait time in line for the visa to become available. Again, we don't know how much more time it's going to stay current, probably for some more due to that there have been a lot of unused visas because of pandemic. But
Yeah,
again, we don't know, we cannot predict,
exactly.
that. And again, for example, if you file, what's the good thing about I-824, when you file I-824, it doesn't, you get the priority date of the principal applicant. So you don't have to wait, for example, for as with I-130, you don't have to wait for your categories to become current.
Yeah.
But again, the preference is now current. We don't know how long it's gonna stay like that.
It's all the big unknowns of immigration that we're trying to just better to know it now than later get surprised with it. Anya, thank you so much for coming on the show. If y'all haven't already, like and subscribe or watching this. And if you want to contact Anya to get to know us more, just email her at Anna, ANNA, at JQ, like Queen, KLaw.com. Anna at JQKlaw.com is the best person to contact to schedule a consultation. Thanks for coming on again, Anna. I appreciate it.
Thank you so much, John. Thank you everyone for watching, and we're gonna be making hope more videos on that. We plan to make the separate video on this issue that we slightly touch up on about the special immigrant visas for like foreign workers of the U.S. government.
Yeah.
Yes, stay tuned.
Thank you so much. Bye, everybody.